Yeah, Mungeri is my name. I represent the first accused person, Geoffrey, and also my colleague Ms. Morande. On my left is representing the third accused, whom I also assist in representing. This other one is my colleague. We act together for those accused persons that have been mentioned. Now we are defense lawyers in this case, number 11 of 2025. And today we had an application to have a counsel representing the family of the deceased, requesting that the court bars her from continuing to represent the deceased family because of her conduct, which is in essence conflicting her. She at some point has been taking instructions from our client, and then act for the family. So that's the reason why we were in court to ask the court to stop her or bar her from continuing in this case as a family lawyer. So she has privileged information from the accused person, which she cannot again use or continue, which prohibits her from continuing to represent the family of the deceased. So the ruling by the court has been preserved for the 15th of May. That's where we will know whether the court agrees with us or not.
And what about having the information itself? What does it mean?
Privileged information is information given by an accused to an advocate in a manner that it cannot be disclosed to another party. Now the danger is that having spoken to the accused persons both before their arrest and while they're in custody, going to visit them and even convince them to do an act is professional misconduct. So that's the reason why we're asking the court that at this stage she should be stopped from representing the family.
Could you please explain how it did a fair trial?
A fair trial, then, if she has information on the defense of the accused persons and she's now on the prosecution side, then she already knows the case of the accused person. So it will definitely affect the fair trial. It will definitely injure on the rights to a fair hearing. Yes.
Yes, my name is Advocate Rosalinda Wamaiba. My name is Advocate Rosalinda Wamaiba. Today we're in Nakuru Law Courts. We are just from High Courts for the matter that is the Richard Otieno's case. This is the matter that has proceeded, and I wish to inform the people where we have reached. And I wish to tell the public that today we were in this court. There was an application that was made against myself, being the counsel watching brief on behalf of the family. Actually, it is a recusal application that I should recuse myself from this matter. So the application was, I was up with the application a few days ago. I was able to put my response, and today we were in this court for the purposes of arguing that application orally. So the application was argued, we responded. It has taken around 30 minutes to do that. And the judge has directed that a ruling will be made. That will be on 15th of May 2025. That will be the outcome of after the court reviewing the evidence and the facts that has been placed before it.
What were the accusations and your response?
Actually, they were not accusations, they were allegations. There were so many. Some of them were very unbecoming. I cannot talk to them in public because they were personal. And I believe the court will consider that because no evidence has been presented by the applicants. It was just allegation, mere allegations here.
Thank you.
My name is Buto Gechi Benson, an advocate acting on behalf of the Law Society of Kenya for the family. I'm acting together with Mrs. Wamaida in this matter to represent the family. Today, as Ms. Wamaida has spoken, we were in the courts for the purposes of arguing an application that has been filed by the defense side, wanting Mrs. Wamaida to recuse herself from court from the matter of Richard Otieno. We argued that particular application, and we will not be able to say what decision the court is likely to come to, because at this particular point, that is what we call sub judice in law. So at this particular point, we only want to urge the family and every other person who has been following this particular matter to be calm as we wait for the outcome of the court. On our part, we believe that the reasons that were placed before court were what we call scandalous, they are vexatious, and they are frivolous. And we hope that the court, using its discretion, is going to dismiss those allegations. But be as it may be, even after that, our work here is to ensure that the family get justice. And the only way the family gets justice is one of them having an advocate of their own choice to represent them in a matter. So this application goes to the root of the root of fair trial. But for now, let us just wait and see what the court is going to say about the ruling of the court. That is all.
We saw that there were some things you were not served by the defense side.
Yes.
What was
Yes. This application was actually made by counsel who was acting for the first accused person. I believe so. Procedurally, they are supposed to serve every document they have to us, but unfortunately, they did not do that, and that is the reason why we prayed that some of the affidavits that were before court to be expunged from the record, owing to the fact that we had not received the same, we did not have time to look at them, so we will not have that particular opportunity to respond to them. That is the reason why we pray that those particular affidavits be expunged from record.
that you are being caught unaware by this because of the application?
The only application that we knew was before court that was made by counsel for the first applicant, first accused person. But these others that they were making, those were what we call an afterthought. And in law, those ones will just prejudice a fair trial. So they ought to have served us with those documents so that we will be able to respond to them